If someone sues you, can they take your house? Let's say somebody sues you and you lose the lawsuit. Can they take your house away from you? Sadly, the answer is yes. A plaintiff can take your house if you don't have access to liquid assets such as cash in the bank, stock, or the equivalent. So, depending on where you live, the court may force the sale of your house to pay the judgment. And this situation is dangerous for anyone who has a lot of equity in their home and a large judgment against them. However, there are ways to protect your home against aggressive lawyers and creditors. So I put together this guide for you to show you exactly how somebody can take your house, and most importantly, what you can do to prevent it from happening to you. And be sure to subscribe so we can see each other again. So here's what we'll be talking about: how you can lose your house in a lawsuit, example of people having their houses taken in a lawsuit, how to avoid losing your house in a lawsuit, how to protect your properties after a lawsuit, pay your mortgage to protect your house, and set up your home protection before trouble arrives. So here's how you can lose your home in a lawsuit. Now imagine this: you lose a lawsuit unexpectedly, and now your opponent's ready to request a judgment against you. So what happens next? If you can't afford to pay, your creditor can record a judgment in the county that your house is located in, and this creates a lien on your property and turns the judgment from an unsecured debt to a secured debt. Now once there's a lien on your home, you cannot sell or refinance your property without paying the lien. And to make matters more difficult, the opposing attorney often works on a contingency and will not get paid until you fork over the cash, and they're just trying to put food on their own tables. So as a result, they have a motive to obtain legal recourse for your non-payment of the debt and will often rush the repayment of the lien. And if you have enough equity in your home to cover the judgment, there's a high chance that you'll be evicted and your creditor will sell your home. And if you refuse to leave, a team of sheriffs or others will physically remove you. Your possessions will likely be placed on the sidewalk in front of your home or taken to a storage unit. In most instances, you must also cover the cost of such an action in addition to the existing cost of the judgment, or your possessions will be sold to pay for the process. Sounds rather unfun, doesn't it? Now, here's some examples of people losing their homes in a lawsuit. And you may think you'd never end up in a situation that causes you to lose your home, but listen to this. This outcome is more likely than you might think. To show you just how easy it is for somebody to take your house in a lawsuit, we've put together 2 real-life examples of how it can really happen. Example number 1. Here's a recent example from somebody who called us too late. A homeowner did not pay the roofing contractor the $2,500 listed in the contract. In response, the roofer filed a contractor's lien. Now, the judge gave the roofer a judgment, and as a result, the homeowner ended up paying the $2,500 balance. Now, the problem is that the contract gave the roofer the right to attorney's fees and court costs, and that part amounted to $45,000. You know how expensive attorneys can be. The courts gave the roofer the right to execute on the lien unless the debtor paid the $45,000 balance. Now, the homeowner didn't have that kind of money, so the roofer foreclosed and the family lost their home. This example shows that even a small legal fight can really snowball into a much larger problem, and then all of a sudden, the owner of the home is liable for the over $45,000 bill from the lawyer. The debtor had plenty of equity in the house, so it was ripe for the picking. Example number 2, another example of a property owner who failed to pay a $1.1 million judgment for an automobile accident. Now here's the thing, this happens every day. The one who lost the lawsuit had $500,000 of automobile insurance, but the judgment was for $1.6 million, $1.1 million more than the liability limits of the insurance policy. The homeowner did not have the $1.1 million in cash, so the creditor's attorney recorded the judgment in the county where the judgment debtor's home was located. The attorney then foreclosed on the judgment, and the creditor in turn took possession of the debtor's home to pay some or all the judgment. So the moral of the story is that you can lose a lot in a lawsuit, and somebody can take your house, your car, your bank account, and even your life savings should you lose a court battle. The opposing attorney can force you to divulge everything that you own. And as the CEO of the Lawyers Limited law firm in the business for 34 years, I've seen it all. We've seen people lose their homes, their cars, their savings, everything they worked so hard for because they contacted us too late. And that's why we specialize in setting up asset protection trusts, LLCs, and other legal tools to keep people from losing their homes and other assets in lawsuits. So here's how to avoid losing your house in a lawsuit. Fortunately, there are ways to prevent somebody from taking your house after you get sued and after you get a judgment against you. And some of them are only available to residents of certain states, while others can can be used by everybody. So here's just a few of the ways that you can prevent somebody from getting their hands on your house. Number one is homestead exemption. If you live in a state that protects a significant amount of equity in your primary residence, you may be able to use this to protect your home. Now, every state protects homesteads differently, so it's really worth doing some research. We have a page on our website called Homestead Exemptions by State and Territory, and there you can find out how much protection your state offers. Now, to keep you from having to do too much searching, we've assembled an overview of some of the state's homestead laws. So here are some states that don't protect any equity: New Jersey and Pennsylvania. Now, locations that protect unlimited equity are Arkansas, Washington, D.C., Florida, Iowa, Kansas, Oklahoma, South Dakota, Texas, and Puerto Rico. Now, here are some states that protect under $100,000 of equity. 30 of the 50 states protect $100,000 of equity or less. Now, Kentucky, Tennessee, and Virginia only protect $5,000 of equity as of this video. States that protect over $100,000 of equity include California, and allows for a minimum homestead protection of $300,000 to $600,000 adjusted for inflation, depending on the median home price in your county. And this is much lower, by the way, as you probably know, than the cost of a home in the most populous counties. Now, even in states that protect unlimited equity, there are exceptions. For example, you can lose your home if you move to, say, Florida or Texas, and you file for, or your creditors force you into bankruptcy. So you must have lived in Florida or Texas or these other states for at least 40 months before the homestead protection kicks in. Plus, if you're within the limits of a city, you cannot have more than 1/2 an acre to enjoy the full protection in Florida. And this amount grows to 160 acres if you live outside of a municipality. So in short, the homestead protection is a useful way to protect your property. However, since most states don't protect more than $100,000 worth of equity, it's really best to have additional safeguards to protect your home. Strategy number 2 is equity stripping. Now, although your state's laws for homestead protection depend on where you live, anybody can use the equity stripping strategy no matter where you live. Now, to execute the strategy, we record equity lines of credit against your property. We call this equity stripping because it strips the value or equity from the property. So this process creates a paper lien that is initially payable to an LLC, such as one inside of your asset protection trust. And after the paper lien is created, we even have third-party lenders to further separate you from the equity in your home. However, we rarely need to go that far. And as part of this strategy, we set up an asset protection trust. The lender then places the proceeds into an inaccessible account inside of your asset protection trust, and they can even pay you interest on the proceeds. So you'll have to pay interest on your loan, which shows the court that your loan is payable to a true third-party lender. So essentially, this means that you have no equity in your home, having taken out a loan against it. Thus, the person who sued you is much less likely to go after your house and execute a judgment because there's very little to no equity in your home. Strategy number 3 to protect your home: land trusts. Now, a land trust is a privacy tool. It helps prevent lawyers from linking you to the property that you own. So when somebody brings a potential claim to a contingency fee attorney, the attorney typically performs an asset search on the potential defendant. If that potential defendant is you and the attorney sees no assets, it really decreases the likelihood that the attorney will take the case. This is an excellent choice for high net worth individuals who have a higher risk of being subjected to frivolous lawsuits. Strategy number 4 is an LLC. Now, an LLC can provide a mid-level of asset protection, but that protection comes at a cost. Putting your home into an LLC can affect your home ownership tax benefits. And this includes benefits such as selling your home and receiving the $250,000 to $500 of the profits tax-free. So given the impacts an LLC can have on your tax benefits, we typically recommend a land trust instead. Now, in some cases, there are tax benefit exemptions for single-member LLCs. Additionally, married couples in community property states may be able to retain homeowner tax breaks after putting their residences into LLCs. So check with an attorney or CPA in your area to see if the LLC strategy will work. How to protect your properties after a lawsuit. Now, to protect rental properties or any other property that isn't your primary residence, we typically place each property into separate land trusts trusts. And we do this to make it hard for contingency fee attorneys to discover them. So once the property is in a land trust, we create an LLC that is listed as the beneficiary of the land trust. So placing rental properties into a land trust and making the LLCs beneficiaries of each land trust works because many states offer charging order protection for LLCs. So when somebody sues a member of an LLC, there are protective provisions that prevent creditors from attaching judgments against company members to company ownership rights. So in short, the judgment creditor cannot take the LLC outright. All the creditor can do is record a lien in the member's interest in the LLC, and this lien is called a charging order. Now keep in mind, in most states, they require the LLC to have 2 or more members before offering the benefits of charging order protection. Now some states like Wyoming, our favorite in the US, offer charging order protection if the LLC has only 1 member. The laws in Nevada, Delaware, South Dakota, and Alaska also include single member LLC charging order protection. But keep in mind, you have to live in that state, because if you don't live in that state, the state where you live will apply whatever the laws are in that particular state. And if you have 2 or more members, it doesn't even matter if you have an LLC in Wyoming. You have to follow the charging order protection rules in the state where you live. So for the strongest level of LLC protection, you need to establish your company in the Caribbean island of Nevis or the Cook Islands in the South Pacific. So these 2 locations offer many of the benefits of domestic LLCs combined with the inherent laws of lawsuit defenses of an offshore jurisdiction. Okay, next, make sure you pay your mortgage to protect your house. There's one thing we can't protect against: outstanding debt on your home. If there is a mortgage or a lien against your house already, and the law grants your creditor the right to execute on that lien, there is little that can be done to keep your home. So you need to protect yourself before somebody records the judgment. A mortgage is a secured debt, and if you don't pay it, the lender can seize your home as security. So set up home protection before trouble arrives. So if you end up in legal trouble and are at risk of losing your home, it's best to have asset protection in place already. So call us before this happens and not after. Most asset protection strategies are designed to be set up long before trouble arrives and activate when needed. If you set up your defenses too late, you run the risk of losing everything. So don't sit around waiting for problems to find you. Be ready before they show up. So are you interested in setting up an asset protection plan to protect your home and your other assets? We have attorneys and consultants on our staff who can help you. You can go ahead and visit assetprotectionplanners.com just to get free information if you like, or fill out a free consultation form if you want to talk to somebody. So go ahead and subscribe for more, and we'll see you next time. This is The Business Guy.